everybody, and welcome to the second episode of Technology in the Law with me, your host, Frank Jennings, the cloud lawyer. And today we're talking about managing cloud computing risks. And we've got an interesting panel today made up of three lawyers. Is this the real life or is this just fantasy? You have three lawyers for free for the next half an hour. Brilliant. On the provider side of things, we've got Neil Cattermole from Compare the Cloud. We've got Rocío de la Cruz from Gowling WLG. On the customer side, we've got Jimmy Desai from Keystone, and we've got Paul Bevan for Blur Research. What we're going to try to do today is capture some of the arguments for and against some of the issues that people are facing when they're moving to cloud computing. So Paul, straight up, you advise a number of customers. Do your customers know about the risks? Do they care about the risks?
Yeah, they know about and care about risks. The challenge is they're not very good at assessing risk. Risk tends to be a very emotive topic. Quite often it's a gut feel rather than a really good assessment of the likelihood of something happening and the impact if it does. So quite a lot of the risk decisions they make are not based on what I call a really good look at the likelihood and impact statements.
Jimmy, by the time your clients come to you, and Jimmy is a lawyer, he acts for a number of customers looking to make a move to cloud, as do I. By the time the customers come to me, they're pretty much aware of what the risks are. Is that your experience?
Yeah, I think so. They know a lot of the risks. One of the risks is data security and that kind of thing, so they start there. And then they build out from there in terms of finding out where their data is going to be stored, security issues, as we've mentioned, confidentiality, that kind of thing. And then we go through the contracts and try to figure out if the contracts match their expectations.
And Paul, in your experience, do most of your customer contacts go through the contracts before they jump into cloud?
Yes, they
or is
do.
it just an I accept click?
No,
and you're in?
it's a timing issue, isn't it? That, as you say, by the time it gets to the point of jumping, they will give it to either an internal lawyer or an external lawyer to have a look at it in some detail. Whether the individual manager, owner of a business looks at it is another matter, but they will generally pass it out to somebody to look at it in detail. The question is, did they get the lawyers involved early enough? That's sometimes the issue.
And Neil, from your experience on the provider side of things, do people get the lawyers in early enough, or do most of the cloud instances go through on a click, I accept?
It really depends on the size of the organisation, Hank. From an enterprise provider point of view, yes. But when you look at the SME marketplace, I'm not saying that they wouldn't get contracts reviewed and written correctly, but I think they certainly wouldn't be as diligent, without any doubts. And quite often, a cloud provider or a provider in general would back off the terms and conditions to whoever they're working with to go back to back and not necessarily actually go through them thoroughly.
So, Rocío, you write some of the terms and conditions for cloud providers.
Yes.
And is that, do you get much pushback from somebody like me or from Jimmy or even an unrepresented client? Do people go through the terms?
Yes, well, we are seeing that people are increasingly looking at the terms and conditions, and they are starting to be more worried about the obligations if they are processing personal data as well, and how to implement all the requirements that will come into force next year. For the General Data Protection Regulation.
So that's twice we've heard about data security, data protection issues. There are a number of other issues though, and I'd like to go through some of them because this is although we've got three lawyers on the panel, I'm keen to ensure this isn't a half an hour of lawyers talking about law. What I want to do is try to make this inclusive, talking about the cloud risks generally. So as is service is one of my favourites, is you pay good money for a good service. But when you read the terms and conditions, the providers put in there, this says as is service. Is that an issue for you? Is it what it is, or what's your thoughts, Paul?
Again, this is different compared to what type of business they're in, what type of things they're going to put into the cloud. So I think there's a risk at the small end, medium-sized market that they do that and not really aware of the implications of that. But for most larger enterprises, there is such a mix of cloud business. And actually the cloud is not a very helpful term for most of them, that as is certainly doesn't do good because they're actually going to the cloud for a reason, normally to get more agility, more performance, lower costs, all those sort of issues. But they will do it in very different ways for different parts of their business and for different applications. So it becomes quite complex, I think, is the answer.
So is that a justification for as is from a customer point of view, or is that something that people haven't thought about in your experience?
I don't think people have really thought about that. I think,
but the cloud providers have, haven't they? As is for reasons, for all those reasons, is flexibility, it's scalability, it's cost. Is that the justification for it?
It should be.
It's very Californian, isn't it? It's as is, and when it works, it's great, and when it doesn't, oh well, it's not like we didn't try. Let's start again, dude.
The problem is when we're talking in contractually or contractual law basis. From a provider offering those services, you've got to be concrete. And if you have a service that you're delivering to your clients, if it involves something data or anything personal, would an SME service provider go to that level? I'm not so sure. They should do.
Yeah.
But you can't equate or cater for every eventuality. And if you were one of my clients providing a service to you, heaven forbid, you're a lawyer and you'll be reading my contracts first, but quite a lot of people don't read the contracts that I would give them. You would see that it couldn't cater for everything. Even huge public cloud providers have those holes in their contracts.
I do agree, and in fact we have seen two different situations, like Neil said, that when the clients are not, or the customers are not reading the terms and conditions, sometimes they are assuming risks because they are not aware of what the implications of the service, and this is something that perhaps some small medium providers should improve on that, on clarity. And it's going to be mandatory next year anyway, so they need to start thinking about that. Whereas others are more clear, and then perhaps customers will be more comfortable having this relationship and contracting them in the end.
So Neil, you mentioned data as well. So that's three people around this panel have now mentioned data as one of the key risks of cloud. Paul, you're the only person who hasn't mentioned data. But I'm sure that data is one of
There's another part of my world for which data is hugely important. And so yes, there is a strong need to control data. But
so from a customer's point of view, if you've got an as-is service, which means it works when it works, it's available except when it's not, and there's no liability for anything we can think of, including loss of data. How does that place you from a customer's point of view in terms of acceptance of risk? Is that something you're comfortable with, or do you shy away from those?
You'd shy absolutely away from that. Again, it will depend on what applications, what business you're in, but the one I'm talking about is that would be an absolute drop, stop. We're not going anywhere near that. And it's nothing to do with where I store it. It's all those other issues about having responsibility for that data. Legally, they're responsible for it. And again, one of the challenges you see with people is understanding who's responsible. When you go to the cloud, or when you go to any hosting company, and we've been through this a number of times in the industry, is actually who's responsible for the data. And I have to say that customers generally have been lax in understanding their responsibilities when they, for want of a better word, outsource.
Yes.
Whether that's to a cloud or a managed service provider or whatever.
We touched upon data location last week, and next week we're going to be focusing more heavily on GDPR obligations. So that's a neat segue in some ways for people to tune back in next week. So I don't want to spend too long talking about GDPR this week, but I think you're right. It's important from a customer's point of view that they remember that they're primarily responsible under legislation for looking after the data, and the cloud provider will be then the processor. So from your point of view, or from your client's point of view, it's all about following what their instructions are, and yet what we're hearing from over this side of the table is that customers don't necessarily evaluate the risk properly when we're looking to put data into cloud. Would you agree with that, Jimmy?
Yeah, it's quite a general question because in a way what it will depend upon is, of course, the nature of the customer. It will depend on the nature of the data that's stored. It will depend on the price that they pay, so that essentially if they're paying a very high price, they might expect a better service because there will be additional features to that service. So there's so many kind of moving parts here with regard to using the cloud that it's very difficult to come up with a silver bullet to say actually this is it, because it's just this difficult matrix to balance what you're putting on the cloud, etc. And you might have some data that you don't put on the cloud, and you have this matrix system where you put data in different places, depending on your risk analysis of what you should be doing with the data.
Could I interject very briefly on this side of the desk?
Justification from the provider's point
From a
of view.
vendor's point of view. Typically, we've got a contract with our clients that dictate a service level of some description.
Yes.
And that's completely outside of what we're talking about, data patronage and data sovereignty and access. So it's difficult, I think, from a service provider point of view, that we would have a contract of some description with a client that says, this is a definition of service, this is what we will provide to you. And a lot of the time that doesn't actually involve data.
Yeah. Well, SLAs is one of the topics that we're going to be featuring in episode 5. So we'll come back to SLAs in more broad terms then. But I think you make a fair point that it's you're buying a service and maybe from a customer's point of view, you need to say, well, this is the service I'm buying. Maybe I need to pay more, to take your point. You get what you pay for after all. And if you don't pay enough, then maybe you... but from the provider's point of view, and I've said that I act for customers on the one hand, I also act for providers on the other hand, so I'm not so much poacher turned gamekeeper as poacher and gamekeeper at the same time. So from the provider's point of view, it's very well saying, well, we'll follow your instructions to look after the data, but ultimately you're not paying us enough money to justify anything more than an as-is service, and you can't. You're not paying us enough to justify us taking all the risks of your business. Things happen.
And I think there's two different issues that people talk about information governance and get that confused with information and IT security.
Yeah.
So actually a lot of the time people will be talking around governance and expect that everybody, and haven't realised that there's holes in security. And if you look back at the recent cyber attacks, I bet a lot of the issues were because people didn't understand the difference between governance and information IT security. And I think that's a problem on the customer side.
And I think one of the things going on is that one thing that we're looking at with contracts is the caps on liability for a provider, and that's one of the things that is essentially goes to the very heart of risk, is to say, okay, we'll pay this money, this is an as-is service. But if we actually do lose data, if you do lose data or there's a problem, then, and it's truly your fault, then to what extent we can claim against you and what have you excluded, and also even if we can claim against you, how much can we claim before it hits a cap? Because then we will have to pick up the shortfall.
So from a customer's point of view, liability is a real issue. So what do you say from the provider's point of view?
It's a difficult point actually, because now you need to accept or face these risks, but you don't have any support from, for example, insurance companies covering fines or covering possible fines for a breach of data. So it's been really difficult, and we are working more on trying to provide a service which is secure or doing the best in order to keep it secure.
Yeah, as I said last week, I've yet to meet a cloud provider who says that their service isn't secure. And the other thing I'd say there is that if insurance is the answer, and I think you're asking the wrong question, because by that time it's already happened. So from a liability point of view, again, from the provider's point of view, the rationale that I use when I'm advising providers is that you're simply not paying us enough money to take on all the risks and liabilities of your business. But it's also from a provider's point of view, they can have clean hands on this side of the debate by saying, well, if you want all this extra security or the redundancy or the failover, or if you want to reduce your liability, then what you need to do is pay more to get a better, more involved service. So it's an upsell from a provider's point of view. How do customers feel when they're being upsold to?
I suppose one of the upsell responses, if you like, is to say, well, if the provider has got so many customers and so good and sells on the basis of security and standard of service, etc., what's sometimes there's a disconnect between how the provider sells their service and then when you actually look at the terms and conditions and actually see if this actually matches up with the promises regarding security. And if the security is so tight and so watertight, etc., then one would naturally expect that there shouldn't be any caps. And if there are any caps, then those caps should be quite high, because essentially every provider, as you say, says your data's secure, it's good with us. So one might say, well, what's to fear if everything everything's so fine?
When I'm advising customers, I say, well, they've told you that this is very secure and it's available 100% of the time, except all the carve-outs that we on the provider side put in there. Is that not a legitimate argument that if it's so secure and it's always there and it always works, why has the lawyer disregarded what the salespeople are selling and put in all those exclusions?
Well, we as vendors at the side of this desk, delivering a service to clients, in reality, if we're talking about contract and risk, we're delivering a service to you, and actually in no part of the contract I've given you has told you that I can get your data back, or it actually has a disaster recovery policy procedure around it. It's like Frank was rightly saying, if you want that is an extra cost, and it comes at an extra contract agreement, and it's a very misunderstood service from a cloud provider point of view to an end user consumer. They just automatically assume that everything will be able to either restore that data, come back, or nothing will happen. And a lot of that comes down to not reading the contract properly and an educational piece.
I think a lot of it is the point at which you have that conversation. Quite often that conversation for a customer happens quite late, and therefore by the time they put their budget in place, they've got their management buy-offs, sign-offs, and all of a sudden it's, we need to upsell this or cross-sell because we haven't covered something off. You're right, it's an education process, and it really is an education process.
So customers don't necessarily know what's going on, rather than abdicating responsibility because it's in the cloud, the guys will look after it because it's cloud, I'm just going to sign it or click the box.
Correct. There is, as I said, the cloud term is not very helpful because it assumes that everything's going to happen as if by magic. And actually when you look at it, there's varying levels of customer responsibility and accountability depending on the services you buy, and people don't really get to grips with that. It's very late, and to be fair, I've worked on the vendor side too for many years, so I know that actually that sort of, if it's not being said, I'm not going to say it routine doesn't come in until too late. And then it's, we've got to put it in, it's now got to go into the legal terms, and that's when everybody gets into a loggerhead and standoff with each other, and it seems, the argument is, don't let it go to the lawyers, it'll take 6 months to get it out to the lawyers, but it's because they're not involved early enough, early enough in the process to understand what's going on.
So Jimmy, when clients come to you, do you have a checklist for when you're going to buy cloud? By the time they come to a lawyer like you or me, presumably the clients are fairly well versed in the fact that they need to get it checked out. But do you have a standard checklist?
There's pretty much a standard checklist that you go through, and you look for key points like liability, recovery of data. In terms of recovery of data, often we would normally expect that if the cloud provider has lost it, then I suppose it's naturally expected that they will recover it. If that comes at an extra cost to say that actually it's been lost and then actually there's more cost to actually recover it, then that, one has to look at that to say, well, how exactly does that work?
And sometimes the causation chain breaks down here, where you're saying, and it's perfectly legitimate from a customer's point of view, saying, I'm giving you my data, I'm paying you to look after it. You're saying, from the customer's point of view, you've lost it, or it's gone, you need to recover it. From the provider's point of view, that's not always the case. It's even if you have a backup copy, it might be that the version that they've been using, their master copy, has become corrupt for whatever reason, some internal failure or other. The master copy is corrupt, and that's replicated over to the backup copy.
Exactly.
It's corrupt. Well, how can we get back your data that you caused to be corrupt in the first place?
You can't, sadly. But that's
and that's why the terms are so tight.
Exactly. That's why it's so important for the customers understand what they are agreeing with as well, because there are certain responsibility on their actions as well that they need to understand.
And I suppose that's the problem, isn't it? That if, for example, in the NHS or what have you, and the cloud provider's holding data, and there's a data breach, the data goes, then the customer on our side is actually kind of trying to face that, and there might be public scrutiny and that kind of thing, and they're contacting the provider, and then if there's this gap here to say, well, actually we cannot find your data or we cannot recover it, then that puts the customer in a very awkward position, because it's relying on the provider to essentially bring that back so it can talk to its customers or its patients or whoever, and just say, don't worry, things are under control.
And how does the discussion work then from your point of view on the provider's side in terms of justifying the terms and conditions that they be signed up to? They're saying, Jimmy's saying, we're giving you data, you need to look after it. If you don't, then we're going to be in the firing line from whichever regulatory body it happens to be, whether it's the Information Commissioner, the FCA, or any of the other regulatory bodies. And you're saying, well, yeah, but.
I think that the important thing is finding a compromising solution and just for the provider to guarantee that the data is going to be safe. But if something happens that is absolutely out of the nature of the security measure that you put in place, and depending on the fee that you pay for that, and you will be surprised that most of the providers that I'm working with, they are kind of open to further negotiation or to find a compromising solution and to invest in better solutions depending on the client's needs.
And is that purely public cloud, or is that a hybrid cloud we're looking at? Because most of your experience of public cloud is going to be I accept, and if you don't accept, then you go shop around and click on someone else's I accept box. So we're talking about hybrid cloud now. No,
in public cloud, that's an interesting thing. I've been in a situation in that time I was representing the customer where a well-known cloud service provider who is well known for not negotiating terms and conditions. In the end, we could negotiate and change some security measures for that particular personal data.
Was that specifically in relation to handling of data protection, data security, data liability, loss of data?
Well, the worry. Or
was it more broadly about the service as a whole?
It was more broadly because the issue obviously was protecting the personal data stored in that cloud service, but that had an implications on the IT security provisions that they needed to put in place, and they were guaranteeing. And yes, we had the opportunity to negotiate that and to increase the security level. More difficult was the liability cap or negotiating the liability. That's something that.
It raises the interesting question about, again, this balance between the vendor and the client who's got the power. That actually the bigger enterprises can have a role to play in terms of changing, ameliorating terms and conditions. Again, if the vendor then thinks that enough of the market's going to go with it, because back to your point, public cloud is a platform, everybody does it effectively the same way. So the only way they're going to change it is if they see that actually that's going to be competitive advantage for us or worthwhile. They're not going to make one-off exceptions because that's not their model. And again, one of the other things you said to customers is understand the business model of the vendors you're going to. Because if it's an automated one-size-fits-all, then you will have limited opportunity, unless there were big American government contracts with Amazon and the like that started to change the general, because they probably thought they could actually get benefit right across the market.
I think one of the dangers here, just from your side, is that actually what we tend to do, and in this discussion we're kind of putting cloud providers in one bucket, and there are many different types of cloud providers, different sizes of companies. And one of the things that I totally understand is that for many companies, their reputation depends upon them actually keeping the data secure, because actually they're dealing with thousands, tens of thousands, hundreds of thousands of customers, and so therefore their very existence depends on keeping the data secure, making sure they can recover it, etc., etc. So therefore customers do have comfort with many cloud providers simply because the cloud provider's business depends upon it, and therefore they need to invest a lot.
Okay, if we can, what I'd like to do is we've made the point that no provider will sell cloud on the basis of an insecure data storage. I think we'll take that as read, that from the provider side we'll give you this one, that definitely data is going to be secure in the cloud because that's the way that you sell it. So let's talk about one of the other issues then, which I think is quite important, is vendor lock-in. Did in the contract that you were negotiating for public cloud, it's scalable, it's flexible, it's commoditized, maybe it's cheap. Is vendor lock-in the answer to that? Well, we'll give you certain concessions, but you need to spread it out over a longer period. Instead of dropping at whatever 30 days notice, we need you to buy in for 2 to 3 years.
Well, it depends very much on the case and and who the vendor is, and even the marketing or the business scheme under which they are operating in that moment. So I think you can find both options. What do you think?
Yeah, well, I think it's like any business would like to lock their clients in for a long period of time. Whatever way that you can justify that sounds really awful, but it's not meant to that. I would like to retain we would like to retain our clients as long as a period of time as possible. However, we have to be flexible to give you options. It's like leasing an office, a break clause, etc., etc. But does that break clause get invoked when you lose serviceability from the service that I provide you, or you lose service, or how does that get invoked? And there's a bit of a grey area because we are off the air for 20 minutes. Does that mean that you can break the contract entirely, or is there penalty clauses?
So what are you looking for, Paul, from a customer's point of view? Sorry,
I think
is it flexibility, or do you mind being locked in for 3 years in return for certain concessions?
I think it's a balance between the cost and agility and sort of future-proofing. The reality for most businesses is they don't have the technical skill sets to deal with an ever-changing environment out there. We all want completely open systems, open source, open stack, the lot. We want the lot. But the ability to actually deliver that and get it delivered regularly, for many businesses, means that they're prepared to accept more of the, let's call it vendor lock-in, on the proviso that the vendor is acting in a reasonable manner. So I think there's a trade-off. Facebook managed to drive the cost of computing down through the floor. Most businesses can't do that, and they certainly don't have the skill sets to do that. So they'll go with one of the key suppliers who's packaging up everything into hyper-converged to go with that. So, but it's a trade-off. We'd love it to be completely open. But
Jimmy, what do your clients say on this?
I think that when we're looking at contracts, vendor lock-in is almost implicit, because if you're actually going with a vendor, the actual hassle of changing vendors is so much that actually, in effect, you've got an implicit lock-in in any event. And the fact is that the way the data's stored, the different fields, etc., the way you operate, the pricing scheme. So essentially, when you go into a deal, you kind of almost feel like you're locked in. So if the vendor's got a renewal period, so after 5 years it's renewed again, I mean, what are you going to do at the end of 5 years? Take all your data to somewhere else and get it, and there'll be a charge with that and all of that kind of thing. So you kind of, when you go into these deals, you almost know that this may be a very, very long-term deal, and it might not be a complete free decision at the end of the contract to simply switch, because it might come with a cost.
Similar in my experience, actually, is that if a customer's looking to go into cloud, and the customers I have advised, they're reasonably comfortable up to a point that actually it's such a monumental decision for the business to move from on-premise to some kind of cloud scenario, that because of the disruption to the business, because of all the changes to the IT, and because of the, as you say, even the fields for the data, how the data is stored, and actually sometimes they're happy to be locked in because they couldn't contemplate changing all their IT again in even 12 months.
I think we would love to offer you a service for a multi-year contract, I think, in the answer to the question.
Fantastic.
With no break clause.
You two to get together after
but
this.
with fixed premises.
Fantastic. And that's one point that I would like to pick up there is in the few minutes that we've got left now is this putting data in particular fields. And we won't talk about GDPR again today, other than to talk about data portability. So from a personal data point of view, you want to be able to move your data out. That's certainly what the new law says. But even from a cloud point of view, even today, migration of data is key. It's my cloud is here today, and maybe there's a lock-in, or maybe it's flexible, or maybe whatever it happens to be. But in 6 months, 12 months, 3 years, whatever it is, I want to move somewhere else. So what kind of assistance do you provide from a provider's point of view? Migration.
Oh, I don't know where to start with that. I could be here all day.
Which is not going to be a standard service necessarily. We'll give you a certain amount of information. Maybe we'll give you a dashboard. You can download the data yourself. But if you want us to do anything to the data, that's going to be a professional service on top.
Well, from the legal point of view, I think it's one of the most complicated negotiations between the parties, because in all time you need to make sure that the data is going to keep secure under the migration, but also it's the time that it takes for the provider to let or to allow another provider to access that data in order to complete the migration process. I think it requires a lot of different points that you need to clarify with the customer before this process starts, and it's not easy at all.
Some of the largest public cloud providers in the world offer a very, very easy break clause and termination, but will charge you quite a bit of money to exit.
Yeah.
Because of the data migration?
Because many things really, yes, the data migration, the service migration out, and obviously data comes at a cost of migrating out of bandwidth, what you need to replicate that data, and some providers would charge you a lot of money for the additional bandwidth required to remove that data from their infrastructure.
And I think
without mentioning any names, obviously.
There are some providers that may, as part of a very good deal, encourage you to store perhaps more data than you need. And then what might happen over the years is that actually what you've got is a massive amount of data. And then if there's a charge per amount of data to actually transfer it, then you might find that there's such a big exit charge that it's just simply better to stay with your existing provider.
Maybe a final point on that, which I spotted on the internet some months ago, was that data transfer service as a truck.
Yeah.
The service providers had a huge rig with storage, and so rather than your bandwidth issue, they were literally sucking the data into a truck and transporting the truck to the next site
terrible.
in the States.
Maybe again from a GDPR point of view, it's worth mentioning that with the changes coming through, people are going to be thinking about how they store their personal data, and as part of that analysis, it's not just the personal data, because we have to work out which bit of our data is personal, but it's the bigger, broader data piece that maybe actually we're keeping data that we don't need to, maybe we've been encouraged to, or maybe it's cheap, or maybe it's easy, but from a customer's point of view, maybe you need to start thinking that we need to handle our data a bit better. There's no point keeping huge volumes of data if actually it's not necessary. And certainly from a personal data point of view, you shouldn't be keeping data longer than you should be. Is the answer to all of this standard terms from the providers? Whenever I've talked to providers before, they're not keen on standard terms. So I'm going to set you up nicely there.
Well, I don't think there is such a thing as standard terms. This is the problem. You can have base terms and then heads of agreement, heads of terms, and then you have to build on that, because Frank, if I'm selling to you a service from a vendor point of view, your requirement is going to be inherently different to Paul's, and I can't give you that same contract. From a public provider point of view, you have no choice unless we get involved to write your contract around that. But
from an industry standard point of view, there's so many different flavours of cloud that you can't possibly have one size fits all terms and conditions. Would you agree with that from the customer side? Maybe you don't even want them. If the terms and conditions look the same for each and every similar cloud service, would that help from your point of view? They'd have to be reasonable, wouldn't they?
They would have to be, and I agree with the vendor on this occasion. I don't think it's possible yet. I mean, we're talking for many, many years about utility computing, the idea that you just plug it in and it's one service for everybody. We're so far from that at the moment that it's just not possible, I don't think. It would be unreasonable. Maybe as an unreasonable customer, I might say, I want to stand it, but I don't think it's reasonable.
And there's so many variables. There's length of term of contract, there's liability, there's how much you're prepared to pay, there's landmark clients that you might actually, as a provider, have a landmark client and do them a very good deal, but it's an anchor client that you can say that actually these are the kind of clients that we've got. And so therefore, there's so many variables that those terms will always change in sync with the terms that are offered.
And the business, your business requirement will be different each time. the requirement for performance, the requirement for security will be different, and each business will have different parts of its business that are different. So again, standard terms, a long way from it.
So maybe the in-house legal team or the external lawyers for the customers won't get to see half the terms and conditions because they've clicked on an I accept box, and even if they were standard industry terms, maybe those wouldn't be favourable anyway. So, and then of course you've got the risks of shadow IT. Is not just that the legal team or the procurement team haven't seen it, but somebody with a credit card has bought an instance of a CRM solution or data storage solution, and as a result of that, the business doesn't even know what there is. So from a customer's point of view, it's important to try to manage your IT and manage your IT risks, and part of that has got to be you need to know where your IT is and where the risks lie. Then to wrap up today's session, I think it's important that what we take from this is that there is not necessarily a one-size-fits-all solution to this. There will be no industry standard terms and conditions for cloud services because of the many different flavors of cloud. Customers need to identify the risks a bit better up front and obviously try to manage their IT, particularly when it comes to moving into a cloud. And if I can take Paul's point, unfairly summarise what the four of you have kindly contributed today, there's got to tell the difference between IT governance and IT security. It's important that you don't just assume that it's all taken care of. You need to take issue with these things yourself. And Jimmy's point is you pay more, you get more. This is the well-known adage that you get what you pay for, and if you don't pay enough, then maybe there's a reason why your cloud isn't as versatile, agile, secure, or responsive as you would like it to be. But as Neil says, he does want to keep all of his clients, and if doing business with you over a longer period of time with repeat business is the way of doing that. Maybe, as Rothio says, they will negotiate on the terms and conditions because their business is important to you. Thank you very much, everybody, for a stimulating debate on managing cloud risks. I'd like to thank my panel. I had Neil Casamol from Compare the Cloud, Rothio de la Cruz from Gowling WLG, Jimmy Desai from Keystone, Paul Bevan from Bloor Research. I've been your host, Frank Jennings, the Cloud Lawyer. Thank you very much for tuning in. I hope you can join us again same time next week for an overview of the General Data Protection Regulation. Thank you very much.